Welcome to the Leadership for Society Speaker Series. And this year's theme is Tensions, Business, Civic Society, and Politics. And I'm Brian Lowry, Professor of Organizational Behavior at the Stanford Graduate School of Business. And today I'm speaking with Pam Carlin, Law Professor here at Stanford. Pam, thanks for being here.
Thanks for having me.
Great. So you recently argued a case, O'Connor-Radcliffe v. Garnier, in front of the U.S. Supreme Court, which focused on social media and First Amendment rights. Can you say a little bit about the case and briefly summarize what was at stake?
Sure. So our clients, the Garniers, are a married couple in Southern California, parents of a bunch of kids in the local public school system, and very concerned and active citizens. And two of the school board members maintained Facebook accounts, and one of them also had a Twitter account on which they discussed school board business, what they were doing, places they had gone, asking for feedback from the community. And our clients gave them some feedback and they didn't like the feedback, so they blocked our clients. So our clients couldn't post anything in response to what the school board trustees did. And for a while on Twitter, they couldn't even see what was on Twitter. And they brought a lawsuit saying that they had been retaliated against and been denied their First Amendment rights. And they won at trial and they won on appeal, but then the Supreme Court agreed to take the case. And the issue that was in front of the Supreme Court is really whether the First Amendment applies at all. And that's because the First Amendment only covers government actors, so-called state action. And the question here was, given that these two school board trustees had set up the Twitter accounts themselves and set up the Facebook account themselves, did that count as state action? Subject to the First Amendment, as opposed to just being the private acts of people who happened to be school board members. And so that was the issue that was in front of the Supreme Court, is whether the First Amendment applies at all.
And that seems like a really important line. Like, what's the line between personal conduct and state conduct if you're a member of the government? Like, is that what's at stake? Is that what we're arguing about?
That's exactly what we're arguing about is, obviously, if you're having Thanksgiving dinner at your house, you can decide, I'm not inviting my crazy uncle because I disagree with his politics. But if you're holding a town hall meeting, you can't say, I'm going to exclude people because I don't like their viewpoint or the like. And so the question in this case, which is really a question the Supreme Court has not addressed directly since the 1940s, is when does a government official cease to be acting in his or her capacity as a government official and become a private citizen? And the last time the court had a case like this, it was a really horrific racist sheriff in Georgia who beat up and ultimately killed a Black man who had objected to the way the sheriff was treating Black citizens in this county, and then claimed, you can't prosecute me as a violation of federal law because I wasn't acting in my governmental capacity. And that was the last time the Supreme Court really dealt with this issue.
That's really surprising to me that that's the last time it was dealt with, given the importance of this distinction.
Yeah, I mean, that's in part because the Supreme Court spent a lot of time trying to figure out when are private actors acting as the government. But it hasn't spent much time thinking about when are government actors acting as private citizens, in part because most of the time it's pretty clear they're acting as the government, or it's pretty clear they're not acting as the government. And social media changes all of that in complicated ways, because now that's how people who are elected officials communicate with their constituents.
And so how does the Supreme Court think about drawing lines in cases like this? Like, what are the considerations that they're weighing?
So they're weighing, I think, two competing considerations. On the one hand, you want for members of the public to be able to communicate with their elected officials and to receive information from their elected officials. You don't want somebody to be blocked from looking at the website or the social media account or the platform where a government official is providing information. On the other hand, government officials don't give up, and government employees don't give up all of their First Amendment rights by becoming government officials. And so, if the First Amendment restricts the ability of a government official to block people from a website, the other side says that's like restricting them from deciding who can come into their house. So, the court is trying to balance the rights of the public and the rights of the government officials when those two things come into conflict with one another.
And what position did you argue?
So we were arguing on behalf of the Garniers. The Stanford clinic, which I'm a co-director of, represented the married couple who wanted to be unblocked from the Facebook and Twitter accounts.
And what was the crux of your argument?
So the crux of our argument is when you're doing your job as a government official, you have to comply with the First Amendment, and communicating with the public about the things the board is doing and soliciting feedback from the public about what the board is doing and asking members of the public to become involved in the schools in various ways is part of these trustees' job. And so when they're doing their job, they have to obey the Constitution. That was kind of the core of our argument.
Even if they're doing it on a personal account? So my understanding is these accounts had been opened even before they were government officials. Is that right?
Yeah, and we recognize that, they set up these accounts. But it's a little bit like, if you're sitting in your house and you're reading, you're getting prepared for a hearing as a school board member, you're doing your job. Now, the question whether you're doing your job is only the first step in the analysis, which is then you're covered by the Constitution. And then we get to, well, what does the Constitution say about what you can and can't do? But government officials use their private resources all the time to do their jobs. And one of the examples we gave in our brief is a huge part of the federal workforce right now is allowed to work from home. And although the government provides them with the computer that they use, the Office of Personnel Management is really clear that the government doesn't pay for the utilities. The government doesn't pay for you to have a desk in your house or the like. And so you're using the desk you bought, the lamp you bought, the utilities you paid for, but you're still doing your job as a government official. And so you have to obey the Constitution when you do it.
I mean, I take that point. It's really interesting, though, because I'm thinking, let's imagine that I run for office, which I promise I won't do. And I have personal accounts, social media accounts, which I clearly barely use. But I'm using those personal accounts and I say something that's maybe tangentially related to my position in office. Now that is treated as if I have to allow everyone in to comment on anything that's up there. Like this is where I guess the other side of your position. Yeah.
Yeah. Well, that's the hard question is, in our case, one of the things about our case was that literally all of the posts, with 3 exceptions over a 1.5 year long period, that Michelle O'Connor Ratcliffe put on this particular Facebook account involved the school board. So it wasn't that she had like a personal account and then one day just mentioned one thing about the school board. And we say, this is a place where you got to draw lines, and we can trust district courts in the country to draw the line in the right place and to recognize that there will be some accounts that are clearly private. And one of the things that this school board said in its bylaws is if you're going to speak in your personal capacity, you should make that really clear that you're just speaking as a private citizen and not as a school board member. And these people never did that. And they said, if you want, and Michelle O'Connor Ratcliffe, for example, said, if you want to reach me, here's my email address. And she didn't give her personal email address. She gave her school board email address, which suggests to us that she understood she was acting as a school board trustee. But you're absolutely right that, you don't want to deprive people simply because they're elected or because they work for the government. Because, First Amendment covers secretaries doing their jobs in federal office buildings. You don't want to say that they can't have their own personal social media, but you can't let them do their job on their personal social media and then turn around and say, okay, now the Constitution doesn't apply to me. Because if that's true, it's not just you can block somebody for being opposed to your position on particular issues. If the 14th Amendment doesn't apply, if this isn't state action, you can block people because of their race, because of their religion, because of sexual orientation, because of their nationality. And that's a pretty scary thing when so much of the public interaction with the people who govern them is done over social media.
That raises the next question for me. I mean, the Supreme Court takes up issues because they have incredible importance for the broad public for the country. And so if they rule in favor of your clients, what's the consequence and what should we worry about, right? Because all these things are really complicated as you're
Yeah.
highlighting. So what if they rule in favor of your clients? How does that change? How's the world different the next day?
So most of the states, most of the country is already governed by a similar rule to our case. That is one of the reasons the Supreme Court took this case, is because there was a disagreement between the Sixth Circuit, which didn't find state action in an equivalent case. That's the circuit that governs Michigan and Tennessee and Kentucky, Ohio, and the Ninth Circuit, which governs the West Coast. So in a lot of places, the law won't change very much at all. And the battleground will shift from, is this state action at all, to whether the particular action that a local government official or a local government employee took is what's sometimes referred to as a reasonable time, place, and manner restriction. So saying that the First Amendment applies doesn't mean you can't block people. You could have rules of conduct that say, if you post more than 15 times in a day, I'm going to block you. If you post something that's threatening, I'm going to block you. If you post about things that aren't relevant, I'm going to block you. And all of those would be permissible rules. So for example, if you're a school board member, you can say, you cannot post on my site advertisements for your dog walking business. If you hit a comment and you put that in there, I'm just going to block you. And that would be okay. In the same way that the government can say, if we're having a town hall meeting to discuss zoning issues, you can't come in here and talk about whether we should be supporting Ukraine or not.
I mean, if you can make up the rules you want about when you block people, it seems like
Well,
that's a big loophole.
Well, they've got to be reasonable rules. They can't be, so they can be rules about, and the other thing is that if you're a government official and you just want to use your Facebook account or your Twitter account as a one-way kind of bulletin board, you don't have to allow comments on those sites at all. It's just if you allow comments, you can't block people because you disagree with the position they're taking on an issue that people are entitled to post about.
I see. And then this gets into a question of content moderation. So you're saying, in essence, that the officials, even if your clients are root for, people can still block people. Like they can have reasonable rules about who can be on their sites or not.
Yeah.
And I think that is content moderation. What about the people who own the platforms, the businesses who run the platforms? So it's still the case that they have content moderation rules and that they can block people. How do I make sense of that in the context of your case or in the broader kind of social media landscape?
Yeah, I mean, that's a really complicated question. And it goes back to the fact that the platforms themselves are private entities. They're private corporations. So they're not covered by the First Amendment. As you may know, there are a set of cases that are up at the Supreme Court this year about that issue. Those are the net choice cases where Texas and Florida essentially enacted laws that told social media, the big social media platforms, you can't toss people off your site. You can't block statements by politicians on your sites and the like. And the platforms are actually raising their First Amendment rights in response to that. So there's that complexity. Then there's another complexity that comes from the fact that there's a part of the Communications Decency Act called Section 230 that protects platforms from liability for some of the things that other people say on those platforms. And then on top of that, there's yet another case that's at the Supreme Court this year that's sometimes called the jawboning case, which is about an injunction that a couple of red state attorneys general got against the Biden administration, telling them that they shouldn't be allowed to put pressure on the platforms or to communicate with the platforms about trying to persuade the platforms to take down disinformation. So we have an 18th century constitution and an 18th century First Amendment that's dealing with a bunch of 21st century social media corporations, in which corporations now have a kind of power over communication that at the framing they just didn't have. And how to respond to that is a really hard question, right?
Yeah, so I wonder, why is this different than, say, TV or radio? So those were also private industries. They had a monopoly on mass communication for some period of time. I mean, obviously, they became incredibly important for politics and for connections between politicians and their supporters. I mean, it was more of a one way, right? So the case that you're dealing with wouldn't be particularly
Yeah.
relevant there. But in terms of the private business's ability to make decisions about the kind of communications that go out over their platforms, is it different?
It's a little bit different in a couple of ways. One is that at the point when we just had over-the-air broadcast TV and we didn't have cable and the like, the Federal Communications Commission actually imposed a variety of restrictions on networks and the like. So, for example, there was the fairness doctrine. They had to present both sides. As opposed to, for example, newspapers, which never had to present both sides. And there's a old Supreme Court case from, I think, the 70s, the Miami Herald against Tornillo case, where the Supreme Court said you couldn't force a newspaper to run a response to its editorials or the like. We just had kind of second half of the 20th century, there was a kind of elite consensus that was in the broad middle of politics. And the combination of that and the FCC controlling the airwaves meant that we just had a different media environment than what we now have, which is almost an infinite number of media channels plus social media. I think in the 1970s, 80% of people got their news from one of the three major networks. And now, we have an array of networks that people can look to for their news that are so different one from another, you wouldn't know that they were all reporting on the same story.
Mm-hmm. And so I wonder if you think about social media in terms of now this kind of two-way relationship between the government officials and the people they are representing. Does social media represent a fundamental change in the way that government is operating?
So I think it's hard to say whether it's a fundamental change in how government is operating, but certainly a fundamental change in how communications between government officials and the public are operating. There's no longer an intermediary for a lot of these places, or when you have an intermediary, the intermediary is not itself a media entity. It's one of the social media companies, and their entire interest is in the market for eyeballs. And that has the effect of, people's attention spans have gotten shorter. There was an old line about local TV news which was if it bleeds, it leads, which was they'd have like the first story was always some crime story or a horrible accident story or like, and now that's been exacerbated. The news cycle is completely different than it used to be, and all of that has an effect on how people interact with government officials.
Mm-hmm. All right, so I'm gonna make an argument against your position for your clients. So, in favor of like the civic health, if you allowed government officials to block whoever they wanted, it could be the case that social media becomes less important as a way to interact with the people that you represent, simply because a vast majority, like a number of people, don't have access to it or don't feel like they would. Would that be such a bad thing? Like, because I wonder how we feel about, like, part of what I think is underlying some of your comments is a concern that social media controlling like the kind of the public form, the public space, right? When what their concern really is eyeballs. And so that could lead to some kind of perverse incentives you could imagine. And so one way of dealing with that is trying to reduce the importance of social media as a place of public engagement with government. And then why wouldn't you then say, like, look, this is all private, you can do whatever you want, as a way of reducing the importance of that medium?
Well, if that's the way people deal with, if that's the way that the public deals with all of its other communications, the question is what will replace it?
Hmm.
That is, if you could actually go back to a world of face-to-face discussions between local elected officials and the public, if they would actually hold town hall meetings and people aren't working two jobs or, finding it hard to get to those public meetings, or like, yeah, it would be ideal if we had a kind of civic culture in which people interacted face to face. But what the question is, what's likely to happen if you allow people, critics of the government, to be blocked from social media? So the only thing that the other people on that social media see is support for the government official. That is, if the government official can block everybody who says, no, I don't think we should ban those books from the schools, then everybody who goes to that public official's website for information, and they're not going to block the whole public, right? So all the people who go to that website are going to see only people supporting the banning of the book, or only people supporting barring transgender kids from participating on the athletic team. You're going to distort what other people think the consensus, the public consensus is on these issues. So, if I thought, I personally do not participate in social media at all. I don't have a Facebook account. I don't have a Twitter account. When I was being vetted for my job at DOJ in 2013, they seemed shocked. They said, okay, so what about Facebook? No, I don't have that. What about MySpace? They were going back to MySpace and stuff. And I didn't have any of those accounts, which is why I have time to do my work. But for people who do have those accounts, one of my friends who's very involved in politics says that, 18 to 26-year-olds are getting their political information from TikTok. And if that's where people are going to go to seek out information, you really don't want that to be skewed so that they only get one side of the story.
I see. I mean, I'm not sure they're going to get both sides of the story, but I take your point.
That's an idealized world, right? And this is part of the theory behind the First Amendment, right? Is more speech is good.
Yeah.
Good speech should drive out bad speech. And of course, we know all kinds of markets where, counterfeit goods drive out the bad, was Gresham's law, is the bad money drives out the good. And that may be true of what's going on in our political discourse.
So that leads me to another case that apparently did not make it to the Supreme Court because it became moot. That was when Trump was kicked off of Twitter.
Yeah.
Right.
Yeah.
And there was a question about how that should be allowed, and that was making its way through the legal system. But when he wasn't reelected, my understanding is, and you can correct me if I'm wrong, the Supreme Court found the case to be moot because he no longer has standing or something like that.
Well, actually, the case that went to the Supreme Court was exactly like ours, which is he blocked a bunch of other people off of his Twitter account, and then after he got unelected. After he lost the election, there was no longer an argument that he can't block people from his personal Twitter account because now he's not the government. But in the meantime, Twitter then blocked him threw him off of Twitter. And Justice Clarence Thomas wrote a really interesting opinion when the court said, look, this case is moot. The case is not a live case anymore, saying we ought to think about the fact that, the people who got blocked are suing Donald Trump to say you knocked us off, but Donald Trump has just been knocked off. And shouldn't we be concerned about that as well? And so, it's this kind of weird circle.
Yeah. And wouldn't you be really concerned about that? I seem like, given your arguments, you should be like, there's no way they should be able to, they shouldn't be able to block Donald Trump. Is that right?
Yeah. I mean, it's not an argument that they are the government, because they're clearly not the government. But one question, and this is the issue in the two net choice cases that are up at the Supreme Court, is can the government treat Twitter or Facebook or TikTok or any of those kinds of YouTube, can the government treat those the way it has treated what are called public utilities for a long period of time, which is, the electric company has to give you an account. They can't just decide, we don't like your politics, so no account for you, or the like. Bus companies, airlines, right? They're all private corporations, but they have to allow people access to their product in a non-discriminatory way. And so the question in the two net choice cases is, well, can the government start saying to these private corporations, you are private businesses, but you have to give people access to your business in a non-discriminatory fashion. And it's a harder issue when it comes to like Facebook or Twitter or the like than it is with an airline company, because an airline is not in the business of having an ideological view. It's not really a First Amendment kind of, it's not really a free speech or free expression kind of corporation. It's just about getting people from place to place, right? Whereas, Facebook or YouTube, all of these companies have algorithms that make decisions about which things people are going to see in which order, which makes it look in a kind of at a high level of generality, sort of like the newspaper, which decides which things go on the front page and which things they don't cover at all. And we've never required, for example, a newspaper to allow anybody who wants to write a letter to the editor to post that letter in the newspaper. If you go to like the New York Times online, they moderate the comments section of the, so you don't find comments in there that they don't want. They can turn off the comments section. So it's actually it's a really tough question of what do we do when you have private corporations that are kind of controlling people's access to information and their ability to communicate with one another. The telephone company, for example, they can't deny you the right to have a telephone number or to make calls to other people on the grounds they don't like what you're saying.
So it's interesting because this case has not been resolved. And it sounds like, again, the case that you argued in your position depends on an assumption about that. It depends on the assumption that people have access, right? That access isn't being blocked at some other point of entry, because if I don't, your case or your argument seems to me be much weaker if people don't even have access to the platform at all.
Yeah, I think our argument is if you're going to have a platform to which people have access, government officials can't block you because of your viewpoint. And so it does, as you say, take a lot as a given. That is, if these officials, by the end of our case, by the time it got kind of through the Court of Appeals, the government officials were using what are called word filters, which is Facebook allows you to, if I understand it correctly, allows you to give a list of words that if those words appear in somebody's comment, the comment doesn't get posted. And you can put any words in there that you want. So one of the two officials put in words like the, is, a, an, he, she, and like, which means essentially nobody can post. And we say, okay, well, if nobody can post, then you haven't violated our clients' rights by treating our clients differently, which as you were just kind of observing means nobody can post, but at least our clients aren't being treated differently because of their protected speech than everybody else.
I find this fascinating because the givens are not givens. The givens are being contested now.
Yes.
So they're making a ruling on a case where the arguments on each side might depend on decisions that are made in other cases yet to be decided.
Yeah, and that's why in our case, we're really just making a very modest claim, which is when government officials are doing this, they have to comply with the Constitution. And we're not saying what the Constitution, in our case, we're not saying what the Constitution requires or doesn't. We're just saying whatever the Constitution requires, it covers these particular school board trustees. And these school board trustees decided not to challenge the fact that their restriction was not a reasonable time, place, and manner restriction. So, when cases get to the Supreme Court, they're often very highly stylized vis-a-vis all of the messy reality that might be out there in the world.
Well, it's a fascinating case, and I'm really curious to see how it gets decided. And I just wonder what this all means about, this is, in some ways it feels really technical and complex, but really what we're talking about is do people get to interact with their elected representatives in the form that people now interact, right? So social media is just the space in which people interact. And how is that managed? Who gets to decide who's there and who's not there? And I mean, more or less, that's what we're talking about, right?
Absolutely. We did a case in our clinic a couple of years ago, a case called Packingham against North Carolina, where our client was a guy who, when he was in his teens or early 20s, he was convicted of statutory rape for having completely voluntary sex with his slightly underage girlfriend. I think he was 21 and she was 16. And he got his life together. He, hasn't been in any trouble with the law since. And he got a parking ticket. And he went down to City Hall and he explained to them that actually he hadn't violated the law, and they quashed the parking ticket. And he went on his Facebook account and said, "Got my parking ticket quashed. God is good." And a police officer in North Carolina had a list of all the people who'd ever been convicted of a sex crime of any kind in North Carolina, saw that our client had posted, "God is good, my parking ticket is no more." And he was prosecuted under a North Carolina law that made it a crime for anyone who'd ever been convicted of a sex crime to go on any social media site to which minors would have access. And we took that case up to the Supreme Court, and they ruled 9-0 that the law violated the First Amendment, that the government can't do that because, as the court said, and this goes to what you were just saying, Facebook and sites like Facebook are now the new public square, in the way that people used to talk and, the public square outside the courthouse or near the shopping center or the like. Now they talk on Facebook.
Mm-hmm. I mean, this is, it's awfully, not just complex, but sensitive, because it's not, it's not in front of a grocery store or at the mall, right? It's on some, private corporations' platforms designed to generate profit for them. So this is, it'll be interesting to see how it evolves.
Yeah, it's really complicated.
And while I have you, I mean, it's not often that I talk to an expert on the First Amendment. So while I have you, I am lately really what's the word for it? I'm very concerned about, flummoxed by, upset about issues around First Amendment, free speech, and university campuses. So somewhat recently, there was the hearings, and there were 3 university presidents that were, I don't know, testifying is the right term, but speaking at the hearings, and there was an outcry about their response to questions on anti-Semitism. And even before that, there had been a lot of conversations about free speech on campuses, and I'm really just curious about your take on the current atmosphere and your views on free speech at universities.
So let me say one thing first, and then the first thing to say is that some universities are covered by the First Amendment entirely, so state universities. Mm-hmm. In California, as you know, schools like Stanford are covered by the First Amendment to the extent that we're talking about potential discipline of students because of a California state law called the Leonard Law. And then you have purely private universities in most of the country, which are not covered by the First Amendment at all. But they are covered by Title VI and Title IX of the Civil Rights Act of 1964 and the Civil Rights Act, Equal Opportunity Act of 1972, which essentially say you can't have a hostile environment on campus with regard to race or sex or the like. So universities are doing several things simultaneously, right? On the one hand, they are about research and and academic freedom and the importance of fearless discussion of complex and difficult issues. At the same time, they have students who are living there, and this is the student's home. And you have students, obviously, who have all kinds of sensitivities. And so there's this real tension between having discussions that can be upsetting to some people and at the same time, avoiding harassment or bullying or having an environment in which students can't learn. And that tension is playing out in all sorts of ways on its own. And then, of course, it's being weaponized for political gain on top of everything else. So this is a tough time to deal with free speech issues on campus. Really tough time.
And who has the responsibility from your perspective of deciding what the right balance is? I mean, I feel like there's this, in my experience, there are people who want to make an absolutist claims, which always seem to me to be naive, right? Because there are competing interests, both of which, or competing values that are important. And it's an absolute position implies that one is always paramount, and that doesn't seem right to me. So, and maybe you can have a different opinion about that. I'm
No,
curious, but
I think you're absolutely right. You can't have an absolutist rule. I mean, some people want to have an absolute rule that people can say anything on campus up to the point of incite. There comes a point at which speech becomes a crime. So, for example, if I threaten to break your kneecaps unless you give me $50, that speech is a crime. If I try to hire you to be a hitman to go and rub out one of my enemies, and I say I'll offer you $50,000 to kill X, that's a crime. That's solicitation. But there's an awful lot of speech that is quite hurtful, but is clearly, as a matter of First Amendment law, protected speech. That doesn't mean that it's a good idea to have that speech. It doesn't mean, for a lot of this stuff, the remedy for that is to condemn that speech. You don't have to value all speech equally. One of the hard things for universities is to figure out when it should be the institution speaking on these issues and when it should be individual faculty or individual students or groups speaking on various issues. So, the University of Chicago is at one end of the spectrum with what are sometimes referred to as the Calvin principles, because Harry Calvin was the person who wrote them, where that university doesn't take positions. Their position is they don't take positions. Now, we can debate whether they're in fact accurate about that, but the idea behind that is, George Floyd is killed, the University of Chicago doesn't say anything about it. Hamas attacks, the University of Chicago doesn't say anything about it. January 6th, the university doesn't say anything about it. That the university only speaks when it's an issue about the operation of the university. So, if federal funding is at issue federal government wants to pass a law that says you get no federal funding if you have a DEI officer, then they would speak about that, because that would be about the university's operations. So that's at one end of the spectrum. The other end of the spectrum, you have some university presidents or deans of various schools who are constantly making statements about issues of public concern that really don't bear on the university at all. And so there's just a huge range of possible solutions or possible responses. But I think you're right that any absolute position is going to turn out to fit the real world really badly. There are going to be examples where that position just doesn't fit the situation at all.
And then, on the more specifics of these presidents who were just, speaking about these issues in front of Congress or committee, it's tough because you'd say as the faculty can speak, but that's often understood as the university is condoning it because they're employees of the university. Like, at what point does what does it mean for the university to speak as opposed for the university to condone the speech of, say, employees in this case? And I'm going to focus on faculty for now.
So, I mean, in general, the university is not taking a position when faculty members speak about whether the faculty member is telling the truth or not, whether the faculty member's research is valid or not. I mean, obviously, at some level, they make those decisions because that's how they decide whether to hire somebody in the first place or tenure somebody. So, for example, I would assume at the business school, the chances of somebody being hired at the business school who believes that property is theft is low. Right. I mean,
Yes.
Somebody who just comes in as the property is theft, or somebody who comes to the law school and says, the repeal of prohibition is an invalid constitutional amendment. We're not going to hire them. So obviously we're making judgments on their viewpoint. But once faculty members are at a university, when they're speaking on the issues that they have expertise on, the university really generally doesn't take a position on that unless and until what the faculty member is doing is creating a hostile environment for students. So, for example, my personal view on this is that the Sixth Circuit got it wrong when it said that a faculty member had the right to refuse to call students by their preferred honorific. So this was a faculty member who said, I'm not going to call transgender women Ms. whatever, because I don't believe they're really women. And I think that creates a hostile environment in the classroom for that student. Or a faculty member who insists on making, treating students differently because of their race or their religion, or makes statements about that in the classroom. I think the university can discipline that. And at the University of Pennsylvania right now, they're obviously considering discipline against Amy Wax, who's a professor at the law school, who made statements that the university says are inaccurate about the academic performance of students of color in the law school. But that's different than, for example, having a professor who makes pro-life arguments or pro-choice arguments or the like at a medical school, or faculty at the law school who make arguments about is or isn't the Supreme Court wrong in its abortion decisions, or its affirmative action decisions, or its gun decisions. That's what universities have to have. They have to have the ability to have those arguments fully laid out.
Because what was that issue? What got these presidents in trouble, at least in the public opinion, was a question about student speech, and
students
if it should be.
I think the question that was the real trouble question is, what would you do about a student who calls for genocide? Right?
Well, it was a little bit more. It was like intifada, or like the slogans.
Well, but that's what's so interesting is the question that got that got all the press was, a student calls for genocide, and then the question. But notice what the difficulty is, and you put your finger on this immediately, is what does it mean to call for genocide, right? So one group of students says, if you say from the river to the sea, that's genocide against Jews. Another group of students, an equal and opposing group of students, say, if you support the Israeli Defense Forces incursion into Gaza, that's genocide against the Palestinians. And part of what's going on here is the weaponization of the word genocide, so that everything you don't like becomes genocide. There are people who make the argument that abortion is genocide because disproportionate numbers of people who have abortions are women of color. And so you are, if you support abortion, if you support birth control, that's genocide. So part of what made this so difficult is some of those statements are perfectly protected statements, even if they're offensive. On the other hand, simply saying you think genocide is a good idea is protected speech generally. Right?
But
if you're trying to
don't have to protect speech,
to engage in genocide, then it becomes incitement. And then there's this flip side thing, which is, if a student feels I can't learn on this campus because other people are calling for genocide, how do you balance that student's fear and that student's anguish against the speech rights of others? And you can see, with the Mideast argument, where both sides are claiming the other side is engaging in genocidal behavior, do you just say nobody can defend Hamas? Nobody can defend the IDF. That's a really hard line to take.
So I mean, this is where I find it troubling, because I understand why their responses sparked outrage. I'm not confused about it. I mean, the feeling is, you're saying that it's okay to call for genocide, and I get why people would be very angry with that and find that a morally bankrupt position. And my sense is what they were doing is some version of the point is making the point that you were trying to make, or you're making right now, which is it's complicated. It depends on what is actually being said and what is meant. Um, and so I guess I just wonder, is there room for that kind of nuance?
So there is not, unfortunately, room for that kind of nuance in congressional hearings that are called for the purpose of creating sound bites. I think there is room for nuance in discussions on university campuses about how do we engage in the balancing that you were talking about earlier. How do we ensure that everybody feels safe on the campus, that everybody feels that they belong on the campus, that everybody feels that they can express their views, while also kind of instilling in our students an ability to listen to what the other side has to say and to engage in respectful disagreement. Because some of these, there are some issues that are clearly, you know, it's clear that the things that Hamas did are terrible things. And it's clear that the Palestinians are suffering horribly at the present time. Not everything that people think has to be said, and not everything that people think and need to say has to be said in the most incendiary ways possible. And some of what we should be teaching people in universities is how to have difficult conversations in respectful ways. And I think, we've fallen short on that in a number of ways, so that student, and this goes back to the social media point that you were talking about earlier when you said, wouldn't it be better if we could get people off of social media? And this is an area where that's for sure true. People say things on social media that they would never say if they had to say them face to face, or even if they had to say them in a letter. And just anecdotally from my own experience, I testified in the House Judiciary Committee against Donald Trump during the first impeachment inquiry. And I got a huge number, a huge number of really obscene, homophobic, racist, sexist, anti-Semitic emails from people. I got very few negative postcards or letters from people. I got some, but very few. Why? Because just even having to physically write the thing out and then spend the 42 cents or whatever it is on the stamp and take it down to the mailbox probably deters people from saying things that they will say, in a New York Minute on the internet. And that's part of the world we live in, is one in which people have the ability to say very incendiary things without any of the filters that human beings used to have.
And then I completely agree with that. I have one kind of more thing on the university presidents. So one of the presidents was resigned, or let's mean pushed out.
Yeah.
And so you have the situation where, let's assume that what they're trying to do is appropriately reflect the nuance of the situation, and that politically that was a poor choice. Politically, it was a poor choice. What does that say about the institutions of higher education, that this person could be pushed out in this way, and they're presumably the representative of the institution? This is in part the argument for pushing them out, because the argument is that they have now poorly represented this institution. But what they tried to do was some version of what you're saying universities should do, which is like have people think hard about the balance between these kind of competing issues. What does that say about the role of universities and what they can be and should be in society right now?
Well, Liz McGill, who's the president of Penn that you're talking about, she was my student. She was my colleague. She was my dean. She's been a friend for a long time. And she's a person of extraordinarily good judgment who made a communications mistake. And what it says about universities is that universities are running scared in the current environment in a way that they shouldn't. They need to have the courage of their convictions, which is that a lot of issues are hard issues. They require nuance. They require thinking deeply. They involve balancing important but competing concerns. And if universities are not going to do this, it's not clear what institution in the United States is going to do this.
Well, I really appreciate it. Thank you so much for talking to me.
Oh, Brian, it's always a pleasure to talk to you. Thank you for having me.